My Lords, we are still on composite policies, or if you'll forgive me if I use that term, I mean to include the deeming language.
Yes.
And I had addressed your Lordships on, in summary terms, on the authorities. And in particular that a significant majority of them are concerned with whether the conduct or knowledge of one insured impeaches the rights of another. And then we had a discussion about the Corbyn and King line of authority, which takes the composite policy concept into the context of policy limits. The only additional point I wanted to make in relation to that is if one's thinking about the deeming language that we've been talking about, with its reference to separate insurance, but without increasing underwriters' limits of liability. In my submission, it's quite likely that that language is intended to deal with the Corbyn and King type position. So it's saying that each insured effectively will have the benefit of separate limits, but without increasing the overall aggregate exposure, which is, if you like, a contractual way of getting to the Corbyn and King outcome. Now, we say that those authorities are not germane here.
I mean, sorry, I don't quite understand that. If I can just turn up the language. Corbyn and King said that without language of this kind, the limits of liability applied to each insured.
Yes.
And this language says the policy should be deemed to be a separate insurance in respect of each principal insured without increasing underwriters' limits of liability. So why is it getting at the Corbyn and King? It seems to be excluding Corbyn and King.
Well, it's addressing, can I put it this way, it's addressing that concept. About the application of limits, that concept of the application of limits. That's the submission I was making. I don't propose to make detailed submissions about what its effect would be. I'm saying that that is likely the origin of that language. Can I address? I want to come to the authorities, but before I get there, I do submit that it's important that the composite policy or discrete policy point is not taken too far. Mainly, this policy, as in common with many others, is negotiated as a single contract and paid for by way of a single indivisible premium. And no one's saying that the policy means different things for different contracting parties. Indeed, the words of the contract mean one thing, and in my submission they mean it for all parties to it. So the defined terms apply in the same way to all insureds, and in my submission the description of the principal assureds apply to all insureds. And treating the cover as applying separately to Technip does not change that definition. Even in the putative separate Technip policy, KJO remains a principal assured within the language of the policy. The platform that was damaged here remains property that was owned by an entity falling within the definition of principal insured. And in my submission, when one's looking at the endorsement, the language which the principal assured owns is a label that is being used to define the property to which the exclusion applies. And I say that label continues to identify the same property, even treating the policy as applying separately in respect of each insured. So if one envisages a different scenario where the exclusion had said there is no cover for liability in respect of the following property with a list, plainly there could be no argument that that applied to each of the individual nominal contracts. And in my submission, there's no difference here where the parties have used a shortcut or a label to identify the property to which the exclusion is intended to apply. The language in the endorsement property which the principal assured owns is a mechanism for identifying the relevant property. And that is the same, that property is the same, regardless of which insured brings the claim. I should just take you to the cross liabilities clause, because reliance is placed on that by Technip in this context. It's at page 232 of the core bundle, tab 13. And in particular, I think reliance is placed on the first sentence. In the event of one insured incurring liability to any other of the insureds, this policy shall cover the insured against whom the claim is or may be made in the same manner as if separate policies had been issued to each insured. And Technip relies on that. Now, it's common ground that liabilities between insureds can be covered. So, for example, Technip's liability in respect of any of the property that is scheduled in the endorsement would be covered. And also there would be cover in respect, for example, of property that doesn't belong to a principal assured and therefore isn't affected by the exclusion in that endorsement. And other types of liability that might arise between insurers. But what the cross liabilities clause is not doing is saying that any and all liabilities between principal assureds are covered, or changing the meaning of the endorsement. One still has to construe the endorsement in the ordinary way to work out which liabilities are and which liabilities are not covered. But I say this, if anything, the cross liabilities clause supports the judge's construction and makes it more likely that it was another insured's property that's being referred to in the existing property exclusion. Because it is cover for a cross liability in respect of such property that the endorsement is seeking to regulate. If there hadn't been a cross liabilities clause, and indeed instead there'd been a clause saying that the policy does not cover liabilities between insureds, then my learned friend's construction of the endorsement would have much more force. Because in that context, you would only be left with the possibility of an insured being liable in respect of its own property. But I say that it is precisely because one insured can be covered, in principle, in respect of liability to another, that the parties have gone to the trouble of including the control mechanism of the existing property endorsement in respect of the most important, valuable and at-risk property in the project, in relation to the project. I want also to pick up a specific point made by my own friends in context of the cross liabilities clause, which is in paragraph 42.2 of their skeleton argument.
Of their skeleton?
Their skeleton argument, my lord, yes. So I don't know whether you're looking at it in the core bundle. It's page 31 of the core bundle. It's internal page 14 of their skeleton. And they cite the cross liabilities clause that we were just looking at. And then they say this makes it clear that the one principal assured shall be insured on the basis that it is the only principal assured in the contract. In my submission, that's not right. That is treating the cross liabilities clause as altering the other terms of the policy, which indicate who is a principal assured. And in my submission, that contention is at the heart of the fallacy in Technip's case in this area, which is that they effectively say, because there are nominally or deemed to be separate contracts, one reads the principal assured as only being capable of referring to one entity. And I say that is not right as a matter of construction, or indeed as a matter of law. In this context, it's perhaps helpful to consider the position of an other insured. So this is somebody who is...
Your case it really says, doesn't it, that you read the rubric for the endorsement so that it reads, the coverage provided under Section 2 of this policy shall not apply to any claim for damage to or use of any property for which Technip and or where the other companies were placed now.
Yes, it's a long list, my lord. But
it's a long list.
Yes.
And the definition of principal assurers is Technip Saudi Arabia and or Aramco and or Gulf, Kuwait Gulf Oil Company and or associated and so on and so forth. There is no mismatch between limbs 1, 2 and 3 because the definition of principal and insured is and or in each case. So
yes.
It doesn't matter whether one of those within the list is or is not liable, as long as one of them is.
Precisely. Yes, that's right. And can I just pick up the point about other insurers? If one envisages a scenario where the liability for damage to a principal assured's property, let's consider the platform in this case. Let's say that it was damaged by an other insurer, so somebody who's not within the list that your lordship has just referred me to, but is an insured under the policy. So at page 238, for example, other insureds include project managers, and they would include various subcontractors and so forth working on the project. One then has to look at the endorsement and give it some sensible interpretation in that context. Where the other insured is liable for damage to KTO's property, one can't contend that in that context the principal assured is a reference to the party who's liable, because it's another insured, it isn't a principal insured. You see, it's a point that the learned judge picks up in 166 to 168 of his judgment. But the significance of it in the context of this part of the argument is that that other insured would also have deemed to have a separate contract of insurance. And one then has to ask oneself the question, well, in the context of that insurance, what meaning does one give to the principal insured? And in my submission, the only sensible meaning one can give to it in that context is that it means, as my lord has just put it to me, it means those entities identified as principal assureds.
Can I just put the other side of the argument?
Yes.
The definition of principal assureds, insureds, is a list of companies separated by and or.
Yes.
So might it be said, well, the and or means that you take whichever one is relevant to the particular factual situation that you are considering. And in a case where you've got a deemed separate insurance policy with each of those named in the list, the and or allows you to select the relevant one, namely the one who is party to the national contract, national single contract.
Well, the part of that analysis that I would take issue with, my lord, is the last part. I accept one has to identify the relevant principal assured. In fact, that's the debate we've been having throughout this case. But it doesn't follow that it is, in the context of this endorsement, and giving this endorsement a sensible meaning, it is the particular principal assured who is bringing the claim. So
you say it's the one that owns the property.
Yes.
That's the relevant principal assured, you say.
Precisely. So I go most of the way along that argument, and then I slightly diverge at the end of it. But this point about other insureds is significant, because one can't give the endorsement the meaning contended for by Technip in the context of the nominal separate policy that belongs to an other insured. Now, my learned friend's answer to that is to say, oh well, the endorsement simply doesn't apply to other insureds. He says that, he said it this morning, but he said it at paragraph 52.6 of his skeleton as well. And the judge dealt with that. I don't need to take you to it, but he dealt with that at paragraph 168. And he said, and in my submission was right to say, that is a departure from the language of the endorsement. The endorsement, it's 241 if you wanted to look at it, but it says in the relevant rubric, coverage provided under Section 2 of this policy shall not apply to any claim for damage to loss or use of or any property. And then it goes on with the language we've been debating. What it doesn't say, as my learned friend would like it to say, is any claim by a principal insured. Because it doesn't say that, his argument that this does not apply to another insured is a departure from the language of the policy, a departure from this language. It's also a departure which, in my submission, would be a very surprising one. It would entail the reasoning that the parties have gone to the trouble of agreeing a specific endorsement to deal with existing property. They've gone to the trouble of scheduling certain existing property for which cover is to be provided and certain for which it is not. But they have only dealt with liability that might arise on the part of principal insurers, and they've completely left out of account other insurers who, in all likelihood, are just as likely to incur a liability as a principal insurer.
Where does the judge deal with that?
It's paragraph 168 of his judgment, my lord. He starts at 166 on this point, and he deals with the Technip argument that it doesn't apply at 168.
Yeah.
So let me see if I mean, I understand the point you've just made, but you're addressing us on this in the question of this issue of composite policies. And do I understand that you're also saying, well, if you view this as a whole bunch of separate contracts notionally, then you've also got to include the contracts with the other insureds. And it would be extremely surprising if those contracts didn't include this exclusion.
Precisely. That's the point. So I think it's fair to say that the learned judge was dealing with it principally in the context of construction, but it crosses over into this area of the case as well, for the reason the Lordship has just given. And I then come to some of the authorities. I'm only going to go to two of them, if I may. The first one is the Alstom Liberty Mutual case, the Australian case. And you'll remember that this is the case about the insufficiency of packing of some equipment that was being shipped to Australia. And just to remind ourselves, if we go to, sorry, I should have said it's in tab 3 of the authorities panel. It starts at page 80, but I would like to go to page 85, if I may. Page 85. You were shown this morning. It's just to remind ourselves of the nature of the issue. You have the paragraph 9, the unsuitability of packaging clause, and it deems packaging to be adequate, provided that in B, any insufficiency has not arisen through fault or with the knowledge and consent of the insured. So we're immediately dealing with a case which I say is in the line of authorities which is not germane here, about whether the conduct, the defective conduct of one insured impeaches the rights of another insured. And indeed, if we go on in this bundle to page 116, paragraph 143, in the penultimate sentence of 143, you see the issue encapsulated. It was not that, so Alstom has said, it was not to be denied the benefit of indemnity by reason of Crompton Greaves' conduct. So that's the point. And then the last sentence of that paragraph is of some significance. It says, Alstom referred to a number of clauses in the insurance policy in support of this construction. And then we get a citation of certain English authority, which my learned friend showed you earlier. And if we go then to page 118, 151, the judge repeats the fact that Alstom is relying on a number of clauses in the policy in support of its contention that this policy was not to be construed as a joint policy. I just pause there. The issue in this case, not our case, in Alstom, was whether the policy was a composite policy at all. That was the debate there. Because the insurers were saying, no, it isn't. And the insurer was saying, yes, it is. And so one has to understand, as it were, that this is at a prior stage of the analysis anyway. Anyway, he then refers, the judge then refers in 152 and 153, the various clauses that were relied upon by the insured in support of its contentions. I'm not going to go through them, but you'll see, for example, at the bottom of 118, reference to the fact that a vitiating act committed by one insured party shall not prejudice the right to indemnity of another insured party, for example. And the point being made in that case was, well, look at the language of the policy. It is clear from the language of the policy that the conduct of one insured is not intended to impeach the rights of another insured. And at 154, which my learned friend did show you earlier, that's over the page on 119, the judge effectively accepts the construction argument that was being put to it and concludes that it was a composite policy rather than a joint policy. And then as it were, the operative paragraph at 159, so over the page again on page 120, that paragraph contains the full extent of the reasoning in this case on the what might be regarded as the next issue once you've decided it's a composite policy, which is how does the particular clause, the insufficiency of packing clause, apply. I don't need to contend that this decision is wrong, but it contains no analysis of the sort one might want to see if one was going to place reliance on it in this case, of the, if you like, the nexus between it being a composite policy and then the conclusion that one reaches as to the actual effect of a particular clause. Now, it may be that in that case the answer was so obvious that no further analysis was required. But what I do see is that one would be hard-pressed to derive from that case any point of principle that could be applied here. Now, in my learned friend's skeleton, at paragraph 45.4, you can turn it up if you would like to, but it's page 33 of the core bundle. The submission is made at the end of paragraph 45.4 that the judge was wrong to distinguish this decision, the one we just looked at. But I do ask rhetorically what that submission actually amounts to. On any view, it was a very different contract and a very different clause being applied in different circumstances.
Where did he distinguish it?
You'll give me one
The reference given is 174.
I'm grateful, 174. It's in the core bundle at the top of 121. And the distinction comes in the last 5 lines, where he says, in my view, the existing property endorsement needs to be considered in light of its particular wording and in the contractual setting that I have described. I do not therefore derive any assistance from considering very different policies placed in very different circumstances and where the issues have no real similarity with the issue I need to resolve. And in my submission, he was entirely right in that approach.
Well, as a general principle, the utility of cases decided on the meaning of different contracts is not of great help in deciding on the meaning of the contract under examination, unless there's a principle which is laid down.
Precisely so. And in my submission, there isn't a principle. And so the case is at best an illustration of the approach to be taken in relation to that contract in those circumstances. The same point I would like to make in relation to Arab Bank, which is the other case my learned friend placed particular reliance upon. That is in the authorities bundle at tab 2. And my learned friend also criticises the judge for not engaging with Arab Bank. But again, this is a very different contract, raising a different question in a different context. As your lordships know, it's a case about the circumstances in which the guilty knowledge of one insurer will be attributed to or will affect the policy entitlements of another. And if your lordship have page 55 of the bundle, 262 of the internal pagination, at the bottom of the right-hand column, the second half of the right-hand column on page 55, various preliminary issues are identified. I don't want to go through them, but if your lordships are interested to know what this case was about, that is an encapsulation of them. And they are very, very different issues from the issue here. So, for example, one gets in 2 whether the fraud and dishonesty of Mr. Brown is to be imputed or otherwise attributed to JDW. 3, whether Zurich are entitled to rely upon the fraud and dishonesty of Mr. Brown and Mr. Pitts in avoiding the policy, etc. And if one goes then to page 58 in the bundle, in the left-hand column, at the very start of his judgment, Mr. Justice Ricks, as he then was, says, he encapsulates what the question is. If a director, the managing director of an incorporated firm of professional estate agents of valuates issues fraudulent valuations in his company's name, and the company recover under its professional indemnity cover from its underwriters on the basis that the dishonest mind and knowledge of its managing director are not to be attributed to it. That question lies at the heart of a number of preliminary issues which have been ordered to be tried. So the first submission I'd make about this is to invite your lordships to reject the suggestion by Technip that this case is, quotes, directly analogous to the present dispute. Instead, in my submission, to the extent that it's dealing with the particular provisions of the policy in the case, Arab Bank is not relevant or applicable. And to the extent it addresses points of principle, they don't affect the outcome. The only points of principle that one might derive from this case are that conceptually one treats composite policies as if, nominally speaking, they were separate policies for each insured. That much is common ground. It's where one goes from there that is at the heart of the present dispute. The second point to be made about Arab Bank is that there are various clauses in the policy making clear that the fraud of one insured was not to preclude a claim by another. So if one goes, for example, to page 61 in the bundle, 268 of the report, there's a quotation from the policy. It goes on for quite a long stretch. It starts halfway down the left-hand column of page 61 and carries on. And I'm not going to go through anything like all of it, but for example, if one looks at the bottom of looks at the right-hand column. Well, I should start. I apologise. We should start in the left-hand column about an inch up from the bottom. The term insured for the purposes of this section shall mean, and then there's a definition set out in some detail. And about a third of the way down the right-hand column, there's then a proviso. Provided that such definition of the term insured shall not be construed to mean that the company shall indemnify any person knowingly committing, making or condoning any dishonest, fraudulent or malicious act or omission. So the proviso in my submission already makes apparent that insureds are positively to be treated separately for the purposes of dishonesty and fraud. The policy says that. One doesn't need to derive it from some principle of composite policies. And indeed, further down the page, about halfway down the page, the judge sets out cover for fidelity. And towards the bottom of that passage near the bottom of 61, you'll see that it's providing cover for the consequences of any dishonest or fraudulent act of any partner, director, sole proprietor, etc. Provided always, you may see the capital letters provided always, that no indemnity shall be provided under this subsection to any person knowingly committing, etc., etc., etc. And then lastly on this point, if one goes to the next page, so page 62 of the bundle 269 of the report, one has the subrogation provision set out about 2/3 of the way down the left-hand column. And it has a carve-out. The company shall not, however, halfway through that paragraph, the company shall not, however, exercise any such rights against any director, etc., unless the claim has been brought about or contributed by the dishonest, fraudulent, criminal, malicious act or omission of such persons. And there are other parts of the contract considered in Mr. Justice Rick's judgment, which I won't go to. But all of these were important elements of the policy before Mr. Justice Ricks that fed into the questions he had to ask. And it's unsurprising that he then said, for example, at page 65 of the bundle, 272 of the report, in the left-hand column, in the first of the sidelined passages, he says the question of construction, the essential question of construction is whether the policy will respond in the case of the dishonesty of any of the other insurers, etc. The answer to that question is perhaps common ground, but I would in any event state that in my judgment the policy not only does respond in such a case, but has been specifically designed so to do. And then further down the same column, towards the bottom of that column, the last paragraph, in the present case, however, the policy goes much further than is normally done in emphasising that the dishonesty of one insurer will not be held against another insurer who is not complicit. In the sidebarred passage on the right-hand column, he repeats the observation about it being specifically designed to provide cover to innocent insurers. And indeed, on the next page, at the top of page 66, 3 lines down, he said it is appropriate to bear in mind that one of the functions of this policy is to provide cover to an innocent principal, even where the agent has acted within the scope of his authority of the ordinary course of the principal's business. So, I don't say that he didn't go on to consider the composite policy aspects. Of course he did. But it was a very, very different context in which one was pushing quite strongly against the language of the policy in seeking to argue that one director's fraud impeached the claims by everybody else. And I don't think I'll deal further with it other than to note that the other aspect of this case is that Mr. Justice Ricks was very strongly influenced by what he called the draconian consequences of the insurer's argument. Because if they were right, all of the innocent insureds would have been deprived of all cover at a stroke. Now I'm going to come to this, but we would say, in this case, there is nothing draconian about the construction for which we contend. Not least, but not only, because there is cover for all of the property that is scheduled in the endorsement. And indeed that, in my submission, is the very purpose of the endorsement, to provide that cover, to define it, to enable the parties to know what it is, and to enable the insurer to rate it, price it, and charge a premium for it. So we are not talking about a scenario of the nature of Arab Bank, where if one party is right, then there's a dramatic curtailment of the policy of cover. Not by any means. So the learned judge dealt with this he didn't refer specifically to the name of the case, he referred to the various cases that my learned friend had relied on, and said, as in the paragraph we looked at, that they were very different policies in very different circumstances. And that is my submission about that. So what one cannot do is to look at Arab Bank or the Australian case, or indeed any of the other cases that my learned friend has mentioned, and derive from it the answer to the question that your lordships are confronted with. that answer becomes, it remains, a question of construction, to be approached in the ordinary way, to which all of the considerations that the judge mentions in his judgment are relevant. So I do say that in any policy, in this hypothetical bundle of policies for the different principal assurers and different other insurers, one is still required to answer the question, what is meant by the principal assured in the language? Or to adopt my Lord earlier example, what is the relevant insured for these purposes? And that question is not answered by saying, oh, well, it's a composite policy, and it's not answered by the language saying we deem it to be a separate policy. My Lord, just one other authority before we leave this, and that's just to show your Lordship a textbook at tab 12 of the authorities bundle, where we've got a passage from Commodore Merkin. This isn't going to transform the analysis, but it's a useful encapsulation. Sorry, I should say page 413 of tab 12 of the authorities bundle. Now, by way of health warning, this is dealing with warranties, and so it's not precisely on point, but it is dealing with the question of how they apply in the context of composite policies. If we look at the second paragraph, the authors say, a further question arises in this context is whether a warranty is divisible as between co-assured, so that breach by one co-assured does not affect the rights of the others. It would seem that all turns upon the proper construction of the warranty, and in particular, whether it describes the risk accepted by the insurers, or whether it imposes personal obligations on particular co-assureds. So the distinction being drawn there is, if it's imposing personal obligations on particular co-insureds, then you treat them separately. So that's the Arab Bank type example, where there's a separate obligation on the part of the director to make a fair presentation, etc. But if it's defining the risk effectively, then you don't. And I say, adopting that distinction, what the endorsement is doing here is describing the risk that's being accepted in respect of each and every insured. I won't read it, but if your lordships are interested, there's then a discussion of Arab Bank, which in my submission supports the fact that it is very much a different case, on different facts, and of no more general application here. My Lord, I'm going to have to deal with much of the rest of my submissions a bit more briefly, but I may come back to some aspects of the composite policy point, but that's, broadly speaking, the way we put it. Slightly incongruously, can we then go back to the endorsement? And I want to make some submissions about the endorsement itself. And then I'm going to deal with my own friends and rounds 1 and 3. I make, it's at page 241 of the core bundle. And I make 3 initial observations. One of them I have made already, but it describes itself as applicable to existing property in both the title of the endorsement and the first sentence. And this is therefore likely to be, and indeed to be construed in a sensible way, so as to apply, at least primarily, to existing property. That means property in the field. And therefore, in this case, property belonging to KJO. And one of the striking aspects of one of the friends' case is that as far as Technip is concerned, this endorsement, to the extent it applies to Technip, is not concerned with existing property at all. Instead, on one of the friends' construction, it is concerned with Technip's own property, which is only brought to the site for the purposes of conducting the project. And in all probability...
Why do you say that existing property has to be located within the field? as opposed to simply existing at the date of the contract?
Well, can I show your Lordship one passage from David Sharp's book on this contract to try to illustrate why I say that. In my submission, that is how it is to be understood, because in a sense, it may be read as referring to any existing property, but sensibly, it refers to existing property in the vicinity of the project. Otherwise, I ask rhetorically, why bother? So, but can I show you in the authorities bundle at tab 13, at page 422, and at the bottom of page 40, I beg your pardon, my lord, it's page 422.
422.
Excuse me.
Yeah.
It's paragraph 9.4.4 at the bottom. The term existing property has created some confusion. For most industry practitioners, it was always understood to relate to existing field or adjoining field installations, which were already owned or partially owned by an insurer. Anyway, it goes on to say that it also encompasses, as it were, other property in the field that might be the subject of tie-in and so forth. But it is principally concerned with property that's adjacent to the project. And since we've got this open, if one looks on the next page, underneath the quotation, the italicised quotation, clearly the policy is not intended to cover liability for damage to the project works themselves that would be subject to cover under section 1. That's common ground, it's not controversial. And then it says at the point the principal will take ownership of contract works as they progressively handed over. The exclusion is wider, however, and will not cover damage to existing field properties owned by the principal assureds arising out of the contract's construction works. So one can draw a very limited amount from that formulation, and I don't want to overstate it, but there's no sense there of the articulate approach to different principal assureds that's being advanced by Technip in this case. The second introductory point I wanted to make about the endorsement is that, and this has been well ventilated already, but it is not drafted as precisely and accurately as it might be. There's been the discussion of the word for already, and the judge described this as over-compressed, which, paragraph 124 of his judgment, and he was right to do so. A certain amount of comparison was made by my own friend with other provisions of the policy, and I want to look at one in a minute. But I do say that it's a bit of a false premise in my submission to assume this endorsement and the other clauses are all drafted by the same person at the same time, and therefore to, as it were, to look for some sort of coherence.
It's never happened in the history of the world.
No, and the judgment to which your lordship referred before lunch, you made exactly that sort of point, that these things in the way of it, there are accretions over time. But anyway, I make that introductory point. We've also
Pick
seen...
and mix, I think I called it in
You
the
did,
judgment on Tuesday.
Yes, you did. A very nice image, if I may say so.
The use of the word easement in limb 2 seems to be bizarre.
Yes, I imagine that in different scenarios with different issues, one could find other infelicities in the way that this is expressed. The central point is that one needs to be careful before placing excessive weight on what might be said, although I dispute this, to be the literal meaning of individual words. Can I tell you one other clause?
Well, no individual word can be understood in isolation. You always have to consider it in context.
Precisely. And that really just goes to the primary way that my own friend was putting it, which is that this language only has one meaning, which I say is just not available. Can I show you at page 228 of the same bundle one other clause on the same theme? You've got clause 14, the inspection and audit clause, where in the first paragraph there are references to the insured in the singular, although in my submission plainly this must encompass all of them. And then in the second, one has a different formulation, which is insured brackets S. So, I don't want to spend too much time on this, but really it is not helpful in my submission to look at individual clauses and say, oh, well, look, they used the plural there. Ergo, in the endorsement, they must have meant something else. The reality is the policy is, as many policies are, internally inconsistent and drafted with small inaccuracies. And that is the root of the construction exercise that we're having to engage with.
While we're on this theme, I'm sure this is completely unimportant, but there seems to be something strange going on with clause 18.
I beg your pardon, my lord, which clause?
Clause 18 on the next page. Acceptance.
Yes.
And there's language struck through. And one might have thought, well, that's a deliberate amendment, except that it's not at all clear it is. I mean, in the sense that sometimes you see in policies, stuff is struck through and then it's initialed by parties.
Yes.
But this doesn't seem to be that kind of thing, because if you look at the first line, for example, by accepting the struck through this policy, each assured struck through the principal assured. Yes. It's almost like it's sort of a remainder of a track change that hasn't been properly implemented. Yes.
Well, I'm afraid I can't cast any light on, as it were, why this came to look like it did. It may be an accident of the drafting process. I simply don't know, my lord. I'm sorry.
Well, it's interesting that when it was that may be a bad point, but it does seem they have a bit of a problem with the difference between singular and plural in that clause.
Yes.
Anyway,
and
sure it's going to decide this case.
The third observation I wanted to make about the endorsement, if I may, is this is self-evident. It's worth emphasising, but it has two parts, both of which are integral to its operation. It has an exclusion and a buyback. And one can't understand, in my submission, one can't understand one without the other. This is not like a common or garden exclusion, where you're just saying, I won't accept any liability that relates to nuclear waste. Rather, it is a mechanism for defining the scope of cover that is available. Obviously, the insertion of the scheduled property means that, at least to that extent, this is not an entirely standard form of document. Parties have thought about and chosen to add specific property.
Do you mean that the contents of the schedule are not standard? The buyback, I understood, is standard.
Yes, that's right.
It's only the contents of the schedule that will vary from case to case.
Exactly. I don't want to be thought to be making a submission goes beyond the submission I'm actually making. Yes, it's the particular items of property. But the parties have at least contemplated that it is important to them, in the context of all of the wording above, which I accept as standard wording, to schedule this particular property.
There was one witness, wasn't there, at this, and some experts.
There were content experts and there was a factual witness.
Did the expert witnesses give any expert evidence about the use of this clause?
No,
no common practice?
No, well, they were, I'm afraid, there to talk about repairing oil rigs and the cost of doing so.
Because it was all about the costs and how much it should have cost and whether you needed to put the thing back in action when it wasn't in action at all.
Because one of the peculiarities, I beg your pardon, but one of the peculiarities of the case was that the platform had never been repaired.
No, I know.
And so one had to work out what it would have cost had it happened. And that's what they were there to do. So
it was built in the 60s.
That's right.
Yes.
Yes. It was non-functional at the time of the accident.
Anyway, here we
are. I say that it is of significance that the parties have chosen to include this property, and it does cast light and is appropriately taken into account in casting light on the objective intention of the parties in agreeing with this endorsement and indeed in paying premium for the buyback.
So you would say, would you, when it says for which the principal assured owns that is not otherwise provided for in this policy, that is alluding to the buyback?
Yes. In my submission, that is since it's not, the policy doesn't contain, to my knowledge, any other provision which might be regarded as something which otherwise provides for existing property, then it is properly to be read, sensibly to be read as referring to the buyback. Certainly includes the buyback.
So just to be clear, what coverage is being bought from Technip's, assuming you're right about the exclusion,
Yes.
Technip is buying cover for liability to third parties in carrying out the contract. So this is not employees or anything like that. This is, I don't know if it...
So, if I can posit a couple of examples, my lord. The classic case might be that the project involves tie-in to another piece of property, and in the course of that, something happens.
Somebody else's property.
Exactly. Or indeed, in this context, the principal assurance property, which is precisely why they want to schedule it.
Well, in the buyback.
Exactly, because they think, well, we've got to do this, and in the course of doing it, we will be directly adjacent to a piece of property X, which we know is very valuable, and therefore we want to make sure we're covered for the liability we have in relation to a piece of property X. Now we accept there is also a piece of property Y, which belongs to the principal assured, but that's sufficiently far away that we don't regard that as a material risk, and we don't schedule that, and we don't pay premium for it. So we looked before.
So basically, we haven't looked at the coverage clause very much, but that's at page 232 in the electronic. Underwriters agree, subject to limitations, exclusions, to indemnify the insureds, brackets S, which it should be obligated to pay by reason of liability imposed by law or express contractual liability for property damage caused by an occurrence, provided the occurrence takes place during the project period and arises out of the activities described in the scope of insurance, and that's the project.
Yes.
So what sort of coverage is that if the field is all owned by KJO?
Well, so
If you're right, not
yes.
much.
Well, in a sense, it doesn't matter whether I'm right, because this is the cover that applies irrespective of the endorsement.
Yes.
So, you know, on either of our constructions of the endorsement, the question your lordship has just posed arises, and in a sense, forgive me for saying it, it's not exactly on point, because then it may be that there was limited cover available or needed in respect of people who weren't principal assureds. But, for example, let's posit a vessel that is transiting, a third-party vessel,
That's what I was wondering about.
Yes.
Yeah.
transiting the field during the project.
Yes.
And instead of this vessel colliding with a platform, it collides with a third-party vessel. That's the sort of thing.
It allied with the platform, as we now know.
I beg your pardon, my lord. Yes, it collided with the platform, but it could very well have collided with another vessel. So that's an instance.
I shall find every possible occasion to use the word allision now.
Very good. Well, I hope not on the basis of personal experience, anyway.
But you don't allide if you're driving in a car with a lamppost. It's only ships.
Yes,
Yes.
indeed. So
Just to be clear.
only in your boating experience might that arise, my lord. Can I then deal with what I say are some problems with, some further problems with my learned friend's construction? First of all, he says that the problem with the judge's construction is that it leaves Technip without substantial property liability cover. So, for example, in 39.2 of his skeleton, he says, well, the judge can't be right because it would deprive us of substantially all of the cover we would otherwise have for damage to property. There are various reasons why that submission is wrong. First, and most significant, it ignores the buyback. On the judge's construction, the insureds, including Technip, do have cover for liability arising in respect of the scheduled property, which we've seen from the questionnaire is important and valuable. In any event, the cover for existing property is an adjunct to the Section 2 cover, and this brings us to the debate or the discussion that we were just having. Whatever the endorsement is doing, it leaves untrammelled liabilities to third parties, and one could have a discussion about the extent of those and so forth. But that liability, to the extent that the parties wanted that cover, remains untouched by the judge's construction. And indeed, I won't take you to it, my lords, but we looked at the underlying contract, project contract, before. Clause 14.2, which I don't think I showed you, but is at bundle, supplemental bundle, tab 1, page 40, provides that each party is liable for damage to third-party property effectively according to its own responsibility for it. So envisages that there may well be liabilities to third parties, and they fall where they lie. They lie where they fall. And this project involved numerous activities over a significant geographical area, with sites many kilometres apart. Your lordships have not been treated to the chart that we had at first instance, but there was a chart of the project showing all of the bits of the field that were being worked on and the bits of the field were not being worked on. And that was, at first instance, principally relevant to the question of how close the platform was to the project works, but also was a visual demonstration of the extent of the project, geographically speaking. And of course, it ran over 5 years, this project.
5 years.
Not originally intended to be so, but if your lordships start at the beginning of tab 13 of the bundle, page 218, you'll see that the inception of the policy was in 2010. And I think the incident that gave rise to the claim is 2015, if I'm not misremembering.
Well, the original contract period was until 2013, so I assume it was extended.
I think in the way of all of these large projects, time got the better of them, and it ran over somewhat. And I won't trouble you with all of the evidence there was at first instance about the claims for extensions and so forth, but clearly the issues that always happen in projects of this nature happened here. So there is plenty of significant cover that remains available to the insureds under the judge's construction. And I won't go to it, but paragraph 182 of the judgment, the judge deals with this and explains why, in his view and in my submission correctly, substantial cover remains, including property cover, liability property cover, on his construction. And one other submission that is made by my own friend is that the judge's construction is somehow equivalent to an insured versus insured exclusion. He says that in paragraph 39.2 of his skeleton. That also is wrong. There remains cover for the liability of one insured to another, most obviously in respect of damage to scheduled property. And indeed our case, which the judge accepted, is that the very purpose of the endorsement is to provide and delineate cover for liabilities between insureds. And that purpose would be defeated by, and it is not consistent with an insured versus insured exclusion. My Lord, I've made submissions already about the implausibility of KJO incurring liability in respect of its own property, and in particular in the context of this project, which is the only thing that was being insured by the policy. So I won't repeat those submissions. I do say that it is equally unlikely that Technip would incur liability in respect of its property. Now, I don't say that it's beyond the wit of man, and certainly it's not beyond the wit of Mr. McDonagh-Beggars to come up with examples of where theoretically that might happen. But what one's concerned with in looking at the endorsement is not with the question of whether theoretically one can think of a scenario in which there might be a liability on the part of Technip for Technip's own property. One's trying to put oneself in the position of the reasonable policyholder, reading this and thinking, well, what is this meant to do? What is this doing? And looking at examples, to adopt my learned friend's phrase, I've lost, yes, he says in paragraph 52.4 of his skeleton, examining the boundaries of cover and exclusions almost inevitably involves consideration of scenarios some distance away from the core subject matter of the insurance. Now that's a very nice way of putting it, but it's really just a formula. We aren't concerned here with the boundaries of cover. We're concerned with ascertaining the core purpose and effect of the endorsement. And in my submission, that is not illuminated by thinking about or coming up with highly improbable or remote scenarios in preference to the much more probable scenarios on which the judge based his analysis. The next problem with, I've dealt with the schedule of property, I think. The line taken by my learned friend in relation to the schedule of property, certainly in the skeleton argument, he didn't really address it very much orally, is essentially to say that the judge was wrong to place reliance on it. And that's in particular paragraph 39.3 of my learned friend's skeleton. But I do just want to pick up one aspect of that. It's suggested that the judge relied on the schedule to alter the meaning of the endorsement. And in my submission, that's not a fair reading of the judge. What he does is to look at the schedule and conclude that paragraphs 154 to 155 that it is consistent with what he would otherwise, the meaning he would otherwise have accorded to the endorsement. I also say that although the particular property that is identified in the schedule is necessarily specific and isolated to this case, there's no basis for assuming that the type of property is unusual. Put another way round, common sense dictates that in almost every case, the property that is likely to be scheduled is the property that belongs to the field operator. Because that is the property that is close to the project and of the greatest value. So although the schedule may be different in terms of the individual items, or would be different in terms of the individual items in different policies, in my submission, it's likely to be materially the same in terms of the nature of property that's identified. And certainly there's no basis for any assertion or assumption that the schedule in another property might identify property belonging to the contractor, somebody in Technip's position. Nobody, to my knowledge in this case or otherwise, has identified any evidence or commentary suggesting that that was ever the case. And it's highly unlikely, not least because it's not existing property, but also because it's very likely to be insured elsewhere. My Lord, some submissions were made this morning, picking up on, I think, paragraphs 38.6, yes, paragraphs 38.6 and of my own friend Skeleton, the effect that, well, my construction, indeed the judge's construction, doesn't make sense for Technip because it doesn't know what property belongs to who. I say that is really a very unreal basis for construing the endorsement. Technip, or a party in the position of Technip, would know, or would be able to find out, who owns the most significant property, existing property. In this case, as we know, the property owned by KJO was in fact identified and scheduled in significant part. And the inference is that this was because Technip made inquiries as to what property was at risk of damage during the project.
I don't think we know, do we, whether all property that KJO owned in the field was scheduled.
We know that it wasn't, my Lord, because the platform...
somebody may have selected what to schedule and what not to schedule.
Exactly so. But what one would expect, obviously I'm not giving evidence about this, but just saying as a matter of common sense, what one would expect is that a party in the position of Technip would do its due diligence to make sure that the property that was scheduled was the property it wanted to be scheduled. And I was inclined to say, well, if it didn't, then so be it.
Tough.
Precisely. I mean,
you say your analysis gives them proper cover for what they chose to get covered.
yes.
If they were going to damage it, and the fact that they left out a disused platform that they happened to run into is a bit of bad luck, but
Yes.
not your problem.
Precisely, and bearing in mind that the platform, the quantum that the judge found that they would have recovered if the claimant had succeeded was 10 million. That might sound like a lot of money, but in the context of this project, which was hundreds and hundreds of millions of infrastructure being built, it's really very small beer. And even in the context of the property we saw scheduled in the questionnaire, which totaled $1.86 billion of
I'll take
value.
that point with me on my next county court visit, Mr. Brockman. See how they feel.
The submission is really that there's nothing terribly surprising about the fact that they chose not to schedule everything, because some property they would have taken a view wasn't worth paying premium for.
Yeah. And it was hundreds of millions of pounds, this project.
More than that, I think.
More than that.
I'll see if I can get you
I think
the
it's 1.7 billion.
1.7 billion. Well,
1.7
the value of the property that was scheduled was 1.7
7 billion.
billion. The value of the project, we may be able to find this, but is I think even higher than that. It was a massive project involving extremely substantial sums being invested. So the point is simply this: that if they didn't manage to identify every last piece of property, that's not a reason why the endorsement needs to be construed in some different way. That's just
Because they were putting pipelines down as well as building living accommodation and all that.
they were doing a large number of different things. And a related submission that's made by my friend is that the endorsement must apply only to the principal assured whose property it is, because only they would be in a position to provide information to the insurers about that property. That's paragraph 52.3 of his notice. The falsity of that point is demonstrated by the facts of the case. Technip did indeed provide information about property belonging to KJO. So there's not an argument that really goes anywhere. But I do say that in the oral submissions he made this morning, one was really getting into increasingly speculative examples. Things like new principal assureds coming into existence and owning property and so forth. But I can't say that that couldn't happen. But again, one's actually trying to read this endorsement in a common sense way from the position of a reasonable policyholder, not to engage in speculation about relatively far-fetched scenarios and then interpret the endorsement in that light. And what one's confronted with here is, on the one hand, a commercial explanation of what's going on by the judge, which goes right to the heart of the issues that the parties are very likely to have been concerned by. And on the other hand, some attempts by my learned friend, valiantly, to identify potential scenarios that might just be receptive to the interpretation that he seeks to put on it. And so the balance is all one way. I've been given a document which tells me that the estimated contract value, so this is the value of Technip's contract, was $356 million. The value of the property that was going to be installed as part of it would obviously be additional to that. Anyway, suffice to say, it was a very large project. My Lord, I'm going to have to rush through the rest of what I'm going to say, but I'm now, technically speaking, on ground one. But the good news is I've dealt with composite policies, and I'm going to say relatively little about ground two, which is the commercial, or maybe that's ground three. That's ground three. I apologise, but can I just deal briefly with some points on the language? The first argument that my learned friend made, and in my section a critical element of its case on construction, is the argument that the language of the endorsement, in particular the rubric that we've been talking about, creates a link between the principal assured and the claim for which cover is sought. you'll see that, for example, at paragraph 38.1 of his skeleton, which we should, if you don't mind, we should just look at. It's a bundle, core bundle, tab 2, page 26. At 38.1, bottom of page 26. The words the principal assured occur immediately afterwards, which refer to the claim for damage to loss or use of any property and immediately before the principal assured's relationship with the property. Well, in my submission, that's just not true, in the sense that if one looks at the endorsement, the words the principal assured appear immediately after the reference to property. The reference to claim is some time previously in the line before. And as I submitted earlier, any claim there is in broad terms and is not adjacent to or limited by or defined by reference to the principal assured. So if anything is to be derived from the ordering of the words, it's that there's likely to be a relationship between the property and the principal assured, but not necessarily between the claim and the principal assured. The other proposition that's advanced in the paragraph of the low-friend skeleton we were just looking at is that the judge's approach involves giving, quotes, a different meaning to principal assured in both parts of the sentence. The sentence being the rubric. Again, in my submission, that's not right. It might make sense, that submission, if the words the principal assured appeared twice in the rubric. But they don't. It does not say, shall not apply to any claim against the principal assured for damage or loss of use of any property for which the principal assured. There's only one reference to principal assured, and it's used to identify the property in respect of which the exclusion applies. So in my submission, it's not right to say that the judge's approach involves giving a different meaning to principal assured. The next point, relatedly, but a separate point that's made by my learned friend, relates to limb 3. Now, the learned judge dealt with this, the idea that somehow he was giving a different meaning to principal assured in the context of the different limbs. He dealt with this at paragraphs 178 and 179 of his judgment. But could I start at paragraph 150, which is at page 115 of the bundle, page tab 6.
Which paragraph?
150, my lord. So, in the second sentence, so he starts off by saying the exclusion does not generally exclude liability for all existing property. Rather, under limbs 1 and 2, the exclusion is concerned with damage or loss of use of property where there is an ownership or possessory or similar relationship between the property and the principal assured. Limb 3 is concerned with a different type of relationship between the principal assured and the damaged property, namely the source of the principal assured's liability for the damage. And I say that immediately identifies an important and fundamental distinction between the different limbs. The first two are concerned with some sort of ownership or possessory relationship. The third is concerned with the source or nature of liability. And when one goes then to 178 and 179, the judge's judgment, at page 121 to 122 of the bundle, that is in essence what he says. So, and he concludes at the end of 179 that what is different is not the meaning of principal assured, but rather the mechanism by which the exclusion operates. And I say that's absolutely right. Under limb 3, it's the basis of liability that is relevant. So if we're looking for the relevant insured, or relevant principal insured in that context, one is asking a different question in the context of limb 3. There will, in that context, very likely be an identity between the principal assured who is held to be liable and the principal assured seeking an indemnity. but that logic does not apply in respect of limb 1, which is not concerned with why the insured is liable, but rather in respect of what the insured is liable. And in that context, in the limb 1 context, it's inherently improbable that the property for which there is a liability differs depending on which party it is that has the liability. So I adopt and urge on your lordships the approach taken by the judge. This is not giving a different meaning to the principle assured. It is reflecting the way in which there are different mechanisms at play in the different limbs of the exclusion. There's nothing wrong with that. One doesn't even get into the authorities that my learned friend was relying on, and indeed the Lord Hoffman decision that I think your lordship referred to, because one's not actually applying a different meaning. One is picking, as it were, from the pool of principal assurance appropriately for the mechanism that's in play. But in any event, I adopt what your lordship said, that it isn't an invariable rule. It all depends on context. I think that's a point we made in our skeleton argument. Now, some reliance was placed by my learned friend on other exclusions in the policy, where he said, oh, well, look how this exclusion operates, and therefore the inference should be that the endorsement operates in the same way. Obviously, one can anticipate what the submission is that I'm going to make about that. But could I just draw your lordship's attention to one point in a textbook that is helpful here? That's it's the Reed book on constructional risk insurance at tab 11 of the authorities file. And it's the additional pages that have been added in. I wanted to go to page, I think it's 407B.
407B or D?
B.
B.
B, yes. At the top of the page, there's, it says, in summary, the exclusions cover. And then there's a footnote, 564. And if one looks in the footnote, halfway through footnote 564, it says many of the exclusions in section 2 are similar or identical to those in other standard policy forms. In particular, the London Standard wording is entitled, and then there's references. And I only draw attention to that to underline what I say is the sterility of attempting to interpret the endorsement by reference to standard wordings that have been imported from elsewhere into this policy. And one's a very, very long way away from a single draftsperson seeking to adopt a coherent approach across all of these different provisions. And my learned friend then, by way of example, took you to exclusion 6 on page 234 of the core bundle, which is all about liability in respect of employees and the like. And I don't want to get too drawn into the satellite debate about what other exclusions mean, but I will just observe that in making his submission about what exclusion 6 meant, my learned friend relied on contextual matters, such as the availability of employers' liability insurance, to inform the interpretation of the exclusion. And he relied on the particular formulation of the words of the exclusion as supporting his proposition, well, that exclusion only applies to the particular insured who's bringing the claim under the policy. We may be right on the language of that provision and given the context that he referred to. But that is neither here nor there. And indeed, if I had to make other submissions about it, all of the exclusions that are referred to in my own friend's skeleton are really exclusions about, they operate by reference to how the insured becomes liable for something. Say, for example, they've wrongfully dismissed an employee, or they've drilled a well in such a way as to cause damage, or they've conducted subsurface activities in a way such as to cause subsidence. So they're, generally speaking, exclusions defined by reference to liability-causing activities, which is a very different mechanism from the mechanism that we're concerned with in limb 1 of the endorsement. So I could make further submissions, and for the record, I don't accept but all of the exclusions that he's relied on in his skeleton are to be interpreted in the way that he says they are. But that's a debate that really doesn't arise and isn't going to assist you. Can I, though, deal with the cancellation clause, because it was referred to by my own friend this morning. That's at page 228 of the bundle. And some emphasis was placed on the fact that it identifies the first named principal assured as the party able to give notice of cancellation. But again, this really, in my submission, won't assist your issues. In the cancellation context, no doubt it is sensible to provide for a single source of notice of cancellation, so as to have clarity and to avoid any potential conflict between insurers. But again, that simply doesn't bear on the endorsement and what property is intended to be excluded and bought back in the endorsement.
But if you read clause 15 in conjunction with the definition of principal insured,
yes,
you simply look to the definition. When you read the definition, you find that the first of the names which appear in the definition is Technip.
yes. So here, you're given instructions to identify which of the principal assureds is relevant. You're not given those instructions in the endorsement, in the way that my own friend seeks to submit that you are. Similarly, one has the notification provision at 232. The submission here was made, well, the insured giving notice would be the insured seeking cover under the policy. I don't accept that necessarily. And the reason I don't accept that is because there's also a clause in this policy at page 226 which says that the principal assureds shall act on behalf of the other insureds in respect of effectively exercising rights under the policy. So it may well be, actually, that scenarios arise in which Technip, for example, gives notice on behalf of another insured. So I don't accept the premise of my own friend's reliance on this clause. But in any event, it doesn't go anywhere because it's a very different clause dealing with a different thing in a different context. So in my submission, just to cap that part of my submissions off, the judge was entirely right to conclude that the meaning of the endorsement is not illuminated by a general trawl through other very different provisions, which are not drafted by a consistent hand and are not drafted in a consistent way. My Lord, I do now want to say something about commercial purpose, although obviously to a certain extent I've been saying things about it all the way along, in the sense that the context here, which undoubtedly is relevant to the construction exercise, is the commercial framework, the project, the identity and relationship of the parties and so forth. All of that is inextricably linked to the construction process that your lordships have to undertake. Now, my learned friend referred you to the Grove case,
do you accept that the language is ambiguous?
Yes, my lord, in the sense that I accept that one has the words "the principal assured," and one needs then to answer the question, which principal assured? Except that that question arises and it has to be answered.
And I think in your skeleton argument, you accepted that Mr. MacDonald Egger's construction could be extrapolated from the words of policy.
Yes, so I have to accept that in the sense that one can make that argument. I can see why Mr. MacDonald Eggers makes the argument, but that's not the end of the exercise. Obviously, that's the beginning of the exercise. Once one's identified that there's a question to be answered, one then undertakes the process of construction. Indeed, there are other formulations or other interpretations that could be put forward. For example, one might say, in the the context of an existing property insurance, that if the principal assured, is intended to refer to just one entity, it's overwhelmingly likely that that entity will be KJO, because that's the party that owns all the existing property. Now, the judge didn't find that. I'm not submitting that that's the construction, but to answer the questions that have been put to me, that is another way one might approach that. I mean, Mr. McDonald is right in his insistence that it has to be one principal insured, then as it were, the best candidate is the principal insured who actually owns all the existing property. Now, in relation to Grove, all I wanted to say about that is that that was a case in which there was really a major gap, on one view, in the contract. And indeed, in your dissent, my Lord the Master of the Rolls was essentially filling that gap by reference to what seemed to be commercially sensible, and that led to the paragraph of Lord Justice Longmore's judgment that was referenced this morning. And I don't need to make any submissions about who amongst you was correct about that, but the point is that it was on any view, it was a more ambitious exercise than what one is concerned with here. We're not filling gaps, we're reading the policy and working out what it means. So Grove is not really going to help you. I would just like to show your Lordships, I know this will be very familiar to you, but in view of an exchange that took place this morning about how commercial factors play in, I just show your Lordships in the judgment at page 99 of the bundle, paragraph 71 of the judgment below. The quotation that the learned judge set out from the Lukoil case. And your Lordships will be familiar with this, and I'm not trying to tell your Lordships anything that's not absolutely ingrained in your thinking. But it's really where this is a discussion of the unitary exercise, which your Lordships are very familiar with. And just under halfway through that paragraph, it says, if there are two possible constructions, the court is entitled to prefer the construction which is consistent with business common sense and to reject the other. Interpretation is a unitary exercise. And of course your Lordships will read all of this, but I was going to go to the last 6 or 7 lines. This unitary exercise involves an iterative process by which each suggested interpretation is checked against the provisions of the contract and its commercial consequences are investigated. It does not matter whether the more detailed analysis commences with the factual background and the implications of rival constructions or a close examination of the relevant language in the contract, so long as the court balances the indications given by each. So it's very important in my submission to keep separate this exercise that's being described here by Mr. Justice Popple, as he then was, which is the unitary exercise of construction in which you are always testing the different potential constructions by reference to the facts, the language and the commercial implications on the one hand, and a different scenario which is more on the Grove scenario where you're sort of filling in the gaps or departing from what the parties have actually said by reference to commercial factors, where there's obviously a higher threshold and it's a much more rarely seen thing. But I certainly don't, I want to make clear that our submission is that commercial factors are relevant all the way through this exercise in the way that's described in this passage here.
Once the contract has ambiguous wording,
Yes.
you undertake this exercise, as Lord Clark said in Rainy Sky.
Yes.
And that's never been changed, despite the fact that, what shall we say, people have written a lot about it.
Entirely so. And I apologise for drawing that to your Lordship's attention, but I thought it was a helpful way to encapsulate the submission I was trying to make. I do say it's of some significance that my learned friend starts his submissions about this ground by trying to persuade you not to have regard to the commercial consequences by reference to Grove and so forth. Now, that's a forensic point, and no more than that. But it does reflect the reality that throughout this appeal, Technip has sought to criticise what the judge has done in terms of commercial context, commercial consequences, but has failed, in my submission, to come up with a coherent commercial explanation for its construction. Now, I'm going to deal very briefly, just to mention the main criticisms that Technip makes of the judge's approach. I understand them to be two in this area. One is that he prioritised commercial factors over the policy wording. And the second is that the commercial purpose was uncertain or not established on the evidence. I'll deal with the second one slightly more later. In my submission, the first point, that the judge prioritised commercial factors over the words, is just not borne out by the judgment. I won't go through it now, but if one starts at 147 of the judgment and reads on, the judge starts with the language of the endorsement. He weaves in some contextual elements consistently with the guidance we've just seen. And at 154, he's still concerned with and talking about the ordinary meaning of the words. So precisely the exercise that Technip says he should have been performing. And it's really only from 161 of his judgment where he starts to focus on the commercial sense of the competing constructions, which he then addresses together with the factual matrix and the wording of the policy, which I say is entirely in the appropriate unitary way. So I do say, actually, the judge's analysis is a model of the unitary approach that we've just seen described. Secondly, in terms of the basis for the commercial purpose, my learned friend starts by saying, well, the judge couldn't derive the commercial purpose from the wording of the policy because the wording of the policy means what he says it means. That's paragraph 52(1) of his skeleton. But obviously, that's a circular argument. And then one gets the submission at paragraph 52(9) of the skeleton Technip. The commercial rationale of a contract is not always easy to discern. Well, in my submission, certainly in this case, that's the counsel of despair. The judge, rightly, in my submission, had no difficulty identifying the commercial rationale for this endorsement. And strikingly, as I've already said, there was no competing rationale presented by Technip.
At paragraph 161, the judge says that Technip's construction makes no commercial sense. Would it have made any difference if he had thought that your construction made better commercial sense than Technic's? I mean, he's gone a long way saying no commercial sense.
Yes. Well, it wouldn't have made a difference because, as we've seen from the Lucas quotation, you're entitled, once we're in the field of having to work out what the words mean, it's not clear on their face, you're entitled to prefer the interpretation that makes more commercial sense. But I would say he's actually right to say it makes no commercial sense because on Technip's approach, people are buying cover, KGO is buying cover for a liability it's never going to have.
Well, I think you accept that you can dream up scenarios where it could, and that's why I asked the question.
Yes, but I'm not sure in this case one can get to dream up scenarios because, for example, my learned friend's joint venture analysis, there's no suggestion in this case that any such liability could arise in this case for these insurers with this project. So it's not only theoretical, I think it's not even feasible. At least there's no evidence that it's feasible on the facts of this case. Now, if my learned friend had supported that sort of argument by saying, well, look at these, this contractual structure, we might incur a liability here, then perhaps life would be different. But there's nothing of that nature. And indeed, just to take that a little bit further, that joint venture example, one hypothesizes a scenario in which there is an allocation of liability between joint venture partners, such that they both own the same property, but party X has assumed the liability and therefore pays party Y. That's going to be caught by limb 3 of the exclusions anyway. That's going to be an indemnity or hold harmless provision caught by limb 3. So whatever limb 1 is doing, it's not dealing with that scenario. So anyway, I haven't got time to develop that submission further, but that's the essence of those points. Just in terms of what the judge relied upon for his commercial rationale, he relied on obvious inference from the wording and the structure of the endorsement. He relied on the factual matrix, so the nature of the project, the identity of the parties owning the relevant property, the answers to the questionnaire, and he relied on the fact that, as was common ground, premium would have been paid in return for the buyback. And all of the evidence and the logic pointed in the same direction. Now, the couple of anomalies that it's important to identify with my learned friend's construction of the endorsement, if he's right. First of all, on Technip's case, the operation of the exclusion is entirely dependent on the ownership structures that happen to be in place. So you've seen the breadth of the definition of principal insurers, and that reflects the fact that there may be affiliates, subsidiaries, etc., who are involved in a field of this nature. The property might be owned by any or some combination of these entities. Now, on our facts, it seems to be relatively straightforward. Property all owned by KGA, which is two entities effectively operating together. But in other cases, ownership of assets in the field might be held by a parent company or a subsidiary or a completely dormant entity set up purely for the purpose of holding the property. In such a scenario, the endorsement would have no effect on my learned friend's approach, because the dormant holding company, who happens to own all the property in the field, is never going to incur a liability for anything, even on my learned friend's most ambitious examples. And so it's all meaningless. It all turns on who actually owns the property. And a malign insured could entirely circumvent the exclusion simply by transferring the ownership of the property into an inactive entity. It cannot be right in my submission that the exclusion is to be read in that way. That the specifics of ownership, about which the insured knows nothing, the insurer knows nothing, become absolutely critical to the way in which the operation of the exclusion happens. Secondly, second anomaly with my learned friend's construction is that the scope of the exclusion becomes fundamentally dependent on how liabilities are allocated between the various insureds. Now, we know it's common for projects of this nature to involve liability allocation agreements. So on Technip's interpretation, whether liability for damage to any particular property would be insured would turn on the details of those liability allocation agreements. If liability happened to be allocated to the party whose property was damaged, the exclusion bites, because that you're in that sweet spot for my learned friend where claim against insured who owns the property. If by contrast the liability falls on any other party, any other insured, exclusion irrelevant. That's how he says it works. In both cases, in both those scenarios I've just posited, the property is the same, the incident giving rise to the loss is the same, the risk is the same, the value is the same, the terms of the policy are the same. But it's fundamentally different, simply because of the accident of how they've chosen to, where they've chosen to put the liability. Again, in my submission, that cannot be a sensible interpretation of this endorsement. The last point I want to make, and then I will sit down and give my learned friend time to reply, is just in relation to the availability of other insurers, which was one of the points that he made. The submission being made was, well, the reason that the exclusion is there in relation to KGA's liability for its own property is because it may well have other insurance in place. There's a few short answers to that, or two answers I'm going to give now. One is that there is already in this policy, at page 232, an other insurance clause, by which this policy seeks to make itself access to any other insurance that may be available. So that's the obvious way for the parties to deal with the fact that they've got other insurance. The endorsement is a very peculiar and roundabout way to deal with it. The second point to be made in relation to this argument is if the reason for the exclusion is, well, you've got other insurance, why the buyback? There's no logic in buying back cover in the way that they have if, as my own friend suggests, the rationale for the exclusion is you've got other insurance in place anyway. So while it might be an explanation for some of the standard form exclusions, that they exclude things which are insured elsewhere, it doesn't work with the endorsement. My lords, subject to any questions, those are my submissions.
Thank you very much, Mr. Porterbank. Mr. McDonald-Eggers.
Thank you, my lords. I'll try to take this as briefly as I can, and my aim is not to repeat submissions I've already made. It's just to respond to what my learned friend has already submitted. I think, and forgive me, the order I'm taking this is in the order in which my learned friend presented his arguments. The first point is taking into account the fact that this is a composite policy. And the question is, in those circumstances, even though the policy actually requires the person interpreting the policy to treat the policy as separate contracts with each insured, does that also mean one imports the entirety of the description of the principal insured when reading the endorsement? And I say no for essentially, well, a number of reasons. Firstly, it's not a definition as such, it's a designation of a class or a description of a class, which is perfectly common in all composite policies, whether it's project insurance or otherwise. And as my Lord Justice Lewison indicated, that the identification of the principal insureds, as indeed the other insureds, are separated by and/or, which gives flexibility to the reader to identify whether it's the relevant insured or principal insured or the entire class. And what I would mention is in the Australian case, Alstom, and also in Arab Bank, there is a similar description of insurers in the same way. But in those cases, the judge was not deterred from identifying the reference to an insured in one case in relation to a fraudulent claims clause, in the other case in relation to an exclusion, by reference to an individual particular insured as opposed to the entire class. My learned friend said, well, those cases are different in the sense of there are other provisions which are relevant, but those provisions don't touch this issue because, for example, in the Alstom case, the provision my learned friend referred to was a vitiating act exclusion, which only concerns the creation of the contract, not the application or performance of the contract. And in Arab Bank, of course, it's absolutely right to say that, and I think I referred to it when I referred to the head note, there are certain provisions which indicated that a person who's fraudulent is not entitled to claim, etc. But when Mr. Justice Ricks was undertaking the relevant construction in relation to general conditions 1 and 2, he was confining himself to those two provisions. I would ask you to reread that, just to demonstrate what he was doing. So that's what I have to say about that. When it comes to limb 1 and limb 3, and having said, I'm going to take in the order my learned friend does, I'm not, because he made this point towards the end of his submissions, I'm making it now. But if one can go back to the endorsement, which is at page 241 of the core bundle, the first point I would make is that the reference to the principal insured, on any natural reading, would be understood as the principal insured who is liable for the relevant claim. That's what I would say is a natural reading. And what limbs 1, 2, and 3 are doing, and of course we're talking about liability for damage or loss of use to property. And what limbs 1, 2, and 3 are doing are describing the relationship between the principal insured who is liable for that claim on the one hand and the property in question. And that relationship can either be ownership or it can be, by way of shorthand, custody or access, or it could be by reference to an indemnification provision in a contract. Now, there is no indication in relation to each of those 3 limbs that you would have given a different interpretation to the word principal insured. And as the learned judge below said, and I think my learned friend accepts, that when it comes to limb 3, in the context of this dispute, the principal insured must be referring to Technip. But the reason given by my learned friend is that that's referring to the basis of liability, whereas item 1 is referring to the ownership of property. But I say all 3 provisions are doing the same thing. They're describing the relationship between the property on the one hand and the principal insured in question on the other. And when I say in question, I mean the person who's claiming an indemnity for its liability. And so on my construction, you only read the word principal insured in this context to refer to Technip. And because Technip doesn't own the property in limb 1, therefore the exclusion doesn't apply. Now, limb 3, Technip has entered into a contract with KGO and has certain obligations, and the judge found those liabilities to exist. But the judge said they were not obligations of indemnification or hold harmless, and therefore the exclusion didn't apply. Now, if the judge is right, and my learned friend is right, then you read the word principal insured for limb 1 as referring to Technip, KJO, and any other principal insured, which is a very wide class. When it comes to limb 3, you refer to only Technip as the relevant principal insured. And I say that's an unusual and unlikely construction. I've already made the point, and forgive me if I am repeating this, as regards the contents of the schedule, and indeed the Marsh questionnaire. They are peculiar to this particular dispute, but when one is construing the standard form endorsement, you don't take into account the contents of the schedule, you don't take into account a questionnaire, particularly where the questionnaire is actually not a contractual document. And of course, in the questionnaire, you see reference to third party, which I think, forgive me, I forget which of my lords raised this reference, but that phrase, third party, is not repeated at all in the endorsement. I think reference is also made to the fact that Technip was the procurer or proposer for this insurance. And that's true, and I fully accept that. And indeed, I've submitted that already. But as Mr. Sharp says in his book, which is at page 420 of the bundle, of the authorities bundle, if you wish to look at it, paragraph 7.3.1, it's not ordinarily the operator or the owner of property rather than the contractor who procures this insurance. So there's no magic, I say, whether it's Technip procuring the insurance or KJO procuring the insurance or anyone else procuring the insurance. I think my learned friend said, well, there's a matter of, in reality, one has to bear in mind who is going to be the person liable to which this policy responds. And I would say that, and my learned friend comes to the answer Technip, because we looked at the contract between KGO and Technip and the relevant provisions. And also we've referred to the covered activities. The covered activities refer to a wide range of activities, some of which, for example, procurement, relate to obligations which are on the company, not the contractor. But even if KJO is the owner of property, just because it's the owner does not mean it may not bear a liability in relation to that property. It could, if it doesn't, if, for example, it's maintained certain safety standards and those safety standards were not maintained as it promised to do, there may be a liability to others who have suffered because of it. Or there could be the equivalent of occupier's liability. Of course, these are, and there's not just contractual liability which is insured, it's also extra contractual liability, or if you like, liability as a matter of law. And when you see the reference to extra contractual liability, it's not limited to this particular contract. It's any contractual liability, whether it's owed to KJO, to Technip, or to any other person outside that particular relationship. So that one can't look at...
A claim for occupier's liability, surely, would be a claim effectively for personal injury. It wouldn't be a claim for damage to or use of any property.
No, that may have been a poor example, but we are dealing with a foreign legal system as well. So whatever the foreign legal system allows or doesn't allow. But what I was trying to indicate, that the owner of property may well bear a liability in question. So I don't agree with my learned friend's submission that it's Technip who is paradigmatically the person who's going to bear the liability, and one has to take into account the position of Technip. And indeed, Mrs. Justice Cockrell, in the Corbyn and King case, says one mustn't construe a contract just by reference to the paradigm case. She says that at paragraphs 175, 178, and 202 of her judgment. So forgive me, I'm editing as I'm going along, and that will save time, I hope, in the process. Yes. Yes, my learned friend also relied on the first opening sentence of the endorsement at page 241, which is cover for damage to existing property is subject to the following exclusion. But all that is an introduction explaining that there is an exclusion which will apply to the cover, and then one has to look at the exclusion and interpret it. It's not going beyond that. So, for example, when my learned friend says that this also applies to any claim which for an indemnity made by another insured as opposed to a principal insured, I would submit there is no indication whatsoever that this exclusion applies to other insureds. The only insured who's referred to is a principal insured. And the question for this court is, what does that mean? And I've already made my submissions as to that. Yes. As regards the commercial purpose, the commercial rationale identified by the judge is at paragraph 165 of the judgment. And one can, it's at page 118, which is, I agree with Medgulf's submission that the clear commercial rationale for the exclusion is to identify specific categories of property that are excluded, say to the extent the cover is specifically brought back, and that the exclusion and buyback mechanism enables the insurer to assess and price the risk accordingly. Of course, that's true as far as it goes, and it's self-evident, but that doesn't explain the purpose of the provision. It explains the mechanism of how the endorsement on the judge's construction applies. What I would say is to be undertaken and understood in the context of the commercial purpose is two things which are relevant. I've already developed these, but just by way of summary. The first is the exclusion, by reference to Mr. Reed's textbook on construction or risk liability insurance, one has regard to the fact that there may well be other insurance available for property which is owned by a principal insured, and therefore the principal insured as owner will have that insurance. I took you to that reference in Mr. Reed's textbook earlier. He also refers in a footnote to this endorsement at a later paragraph at 25.221, And it may well be worth having a quick look at that now, which is, I think it's 400, the authorities bundle is 407, someone tells me 409, I'm not sure that's right. 407G, thank you very much.
G for golf.
G for golf. So there's a footnote referring to the passage I referred to earlier. You can see here what Mr. Reed says is section 1 of the well card covers the insured project works against physical loss or damage. Other property in which the insureds have an interest, existing property which may include previously constructed facilities such as platforms, pipelines, may lie in the vicinity of the project works. If such existing property suffers accidental damage during the course of the construction project, it should normally be covered against physical loss or damage under its own separate insurance. Now, that would certainly cover KJO, but it would not cover Technip. Now, my learned friend, in answer to that point, said, well, there's the other insurance provision, which my learned friend just took you to towards the end of his submission.
So, as a matter of interest,
yes.
we haven't been supplied with 25222.
Would you like to, I haven't got a copy on me, but would you like me to?
But one notices that what the author is saying, we've only got the start of the sentence. As he goes on, however, where accidental damage is caused to an assured's existing property by another assured, then by virtue of the cross liability clause, and despite section 2, and then whatever else he goes on to say. And Mr. Brocklebank did make some submissions about the cross liabilities clause. Do you have anything to say about that?
Yes, I do. Actually, let me. I'll make sure you get supplied the extra page. But having said I don't have it, I do have it. So if I just read it,
Yes.
it's very short. I mean, it's reasonably short. It won't take, and it's not dull reading. So well, relatively speaking. So paragraph 25222 says, however, where accidental damage is caused to an insured's existing property by another insured, then by virtue of the cross liabilities clause, and despite section 2's care, custody or control exclusion, in some cases there may be cover for any resulting liability under section 2 well card. In particular, even where each and every one of the number of parties are interested in the damaged existing property, and those same parties are all principal insureds under the well card policy. Such parties may not be interested in the existing property in the same proportions as they are in the new project. Accordingly, a third-party liability situation may arise. So I'm not sure Mr. Reed's addressing the issue at hand here. What he's contemplating is you have a number of principal insureds all interested in the relevant existing property. But I'll make sure copies of the extra pages supplied. Forgive me, I should have made sure that was included in the bundle. I should make it clear, it goes on by reference, actually quoting the exclusion buyback, but I don't think it adds any much to the debate we're having.
Thank you.
As regards to cross liabilities clause, all I will say there is that it states if there's one insured owes a liability to another, which is this case, it shall be deemed as if a separate policy is issued to each insured, which is essentially the composite policy point. That's the first point, which is the reason why this construction, I would say, has force is by reference to Mr. Reed's consideration about the possibility of extra insurance, which would cover KJO but would not cover Technip. The second is that, for the reason I've already expressed, is that even though Technip is in a position to ask KJO what property should be included, it doesn't know. For example, particularly outside the project site, it may be of no interest, and it may not know what the ownership structures are. And as I say, they may change. And so even though there is some facility available to Technip to find out what some of the property is, it's not in a position to do so comprehensively. By contrast, KJO, as the owner of the property, knows exactly what it owns and what it doesn't own. And as I say, my learned friend referred to the happenstance of, well, what happens if the property happens to be owned by one insured or another insured? But my happenstance, which I rely on, is, well, you don't know until after the incident, as far as Technip is concerned, whether the property is actually owned by a principal insured or not. And if it's not, it's covered. If it's owned by a principal insured on my learned friend's construction, then there is no cover. My learned friend referred to the fact, the notification provision. This is the provision which I relied on earlier this morning, saying, well, it says the insured shall notify the underwriters of a particular occurrence, etc. And if you look at the clause which follows, there's an admission of liability provision, which says the insured shall not admit liability. Now, it would be a very curious scenario, it seems to me, if KJO admitted that Technip was liable and somehow that was a breach of that clause. It must be referring to the insured who is liable. Now, of course, one can go through every provision, including the exclusion clause, and say, well, the insured must mean Technip, or the insured must mean any principal insured. But my point overall is there has to be some stability in the notion of what an insured is for these purposes. You have to know, is it the insured who's making a claim, or can it be any insured with unpredictable consequences for the purpose of cover? I think I'm almost there, my lords. I think before I want to make one more comment before I do. So I think the only point I want to make is the role of commercial sense. The learned judge below said the constructions my clients put forward, read me, I put forward, had no commercial sense. I don't accept that for the reasons I've given. I've identified two factors which actually underwrite, if you like, the commercial sense of the construction I'm putting forward. But what I do repeat is this notion of, insofar as there is a commercial purpose to this wording, on which the judge relied in order to construe it in the way in which the underwriters wish it to be construed, that commercial purpose has to be clear. And that's not clear, I submit, by reference to the terms of the contract, whatever the factual matrix was, the Marsh questionnaire, and certainly as far as the judge's conclusion at paragraph 165 is concerned, that there was a particular commercial rationale, which I submit is nothing more than a repetition of what the mechanism of cover is, or exclusion under relevant policy. And as I say, unless the commercial policy is clear, it really shouldn't be used too readily to override what I would submit is to be the natural and proper construction of this exclusion. Now, I quite accept my Lord and Lord Justice Lewison's point that if this is the rainy sky point, if there are two constructions available to the court and one makes better business sense than another, then of course the court is entitled to prefer the one which makes better business sense. But my submission is that actually, as a matter of construction, when one looks at the endorsement, one sees on a natural reading that the principal insured must be the principal insured seeking an indemnity or a liability, and that the endorsement is explaining that principal insured's relationship with the property in question. And unless those limbs can be satisfied having regard to those parameters, the exclusion will not apply. And no amount of identification of a commercial purpose, which is not clear on the face of the contract or otherwise, can disrupt or dislodge that into construction. So for those reasons, my lords, and unless, of course, you have any further questions, I would ask my lords to allow the appeal.
Thank you. Thank you both. Thank you to your juniors. Thank you to your instructing solicitors for what has proved a very interesting day. It won't surprise you to know that in the 9 minutes left of the court day, we're not going to deliver our judgments. We will reserve them and hand them down in the usual way in due course. And when we do, please use the draft only for the purpose of providing corrections, agreeing the order and costs. And if you're unable to do so, we will deal with that matter in writing. Thank you.